Looks like everybody's pretty much situated. We'll start with a sound check by Mr. Albrecht. You'll need to turn on your mic, and then the two justices will respond.
Can you hear me?
I can now, thank you.
Thank you, Counsel.
And Mr. Albrecht?
Test, 1, 2, 3, test.
Yes, thank you very much.
Thank you, Counsel.
Thank you. And the appellants may now commence their argument. Mr. Armentrout?
Thank you, Your Honor. May it please the court, counsel. I'm Randall Armentrout and here with Leslie Bohonic on behalf of the appellants in this case. We represent Windsor Window and Doors, which is a company here in West Des Moines that manufactures windows and doors. And we also represent two individuals in this case, Liz Mullaney and Clay Kopic. Ronald Rumsey fell in the workplace and severely injured his back, shoulder, and wrist. This case started as a workers' compensation type of a case. He immediately began getting benefits, and the company's carrier paid for his medical situation. We knew it was going to be a long recovery period because of the severity of the injuries, but the company was able to find light duty, even with severe restrictions, for many, many months for Mr. Rumsey. But what happened was there was an altercation, a disagreement about a medical restriction in December of 2015 that led to his termination. And typically, this sounds like the grounds of a worker comp retaliation type claim because the termination was based on a medical restriction disagreement, and Mr. Rumsey had not yet reached maximum medical improvement on his injuries. However, that claim was not pled. It was pled as a disability case under the Iowa Civil Rights Act. We believe that because Mr. Rumsey was not qualified with an accommodation under the Iowa Civil Rights Act, that the case never should have gone to the jury. And when it did, that the defendants, particularly individual defendants, did not receive a fair trial. And what I want to start with is the individual defendants, if I might. This court decided the Vivian versus Madison case in 1999. It was a narrow certified question from the federal court, but the court did decide that supervisors may be held liable under the Civil Rights Act. The court didn't spend a lot of time with a standard or explaining which supervisors or even defining supervisors. And unfortunately, there has not been a lot of cases from this court that gives guidance, which I submit to the court is needed for the bar and for district courts with regard to individual liability for particularly discriminatory discharge claims under the Iowa Civil Rights Act. There was one case this court did issue, which was the Godfrey case a couple years ago, in which the court stated that individual liability would be confined to supervisors, but the court didn't, again, define what supervisors were. What we think is the one key part of the Vivian versus Madison case is when this court distinguished Sahai versus Davis and said for individual liability, the individual must have the authority to make the hiring decision. And so we submit that is what the law should be. That should be the standard going forward in a discriminatory discharge case. We think that makes sense because even if a person is to be sued, that person can't engage in a discriminatory...
Counsel, let's say that we agree with you on that point. It seems to be a disputed fact in this case about whether Ms. Mullaney and Mr. Kopic had authority to fire the plaintiff here. In a situation where at least there would appear to be a disputed fact on that point, what should the district court have done differently?
Well, first of all, we don't believe there is a dispute with regard to authority. Neither Mullaney nor Kopic were ever even asked by the plaintiff at trial whether they had the authority themselves to discharge anyone in particular or they had the authority to discharge Rumsey. It wasn't asked, the plaintiffs didn't ask their superior, Pete Crevaro, who is the human resources director, whether the subordinates had
Counsel?
that authority.
So how does 21611 aiding and abetting play into these two individuals?
Yeah, if that had been alleged, that we would have to go down the road of figuring out.
So
whether-
is that a separate cause of action in your mind?
I believe it is, Your Honor, and it was not pled here in this case. But we would have to take a look at that too, because the word person also is used in the aiding and abetting portion under subsection 11 there. But we do believe that's a separate claim. But getting back to Justice McDermott's question, we did propose to the court an instruction on this. It's instruction 23 that says for Mullaney or Kopic to have been held individually liable, they would have had the authority to terminate. We don't believe there really was a fact issue that could go to the jury. It seems clear from the briefing that afterwards the plaintiff's counsel combed through the record to find any kind of a question that might make it look like one of the two had the decision-making authority, but it was never asked, and never elicited at trial. Liz Mullaney was a lower-level HR manager who reported to the HR director. And also, the evidence at trial is pretty clear that Mullaney and Kopic made a recommendation to terminate, and they themselves on their own never said that he was terminated or fired. Never took actions like that. They both waited to tell their superior to make the recommendation.
So if we believe that there is a fact issue on that point, what remedy are you seeking?
Well, if the court were to also say that there's no problems with the rest of the verdict against the company,
Right, I'm just talking about the individuals.
Right. We think that the judgments should simply be vacated here. And that's because the plaintiff has not alleged that there's additional damages that would have flowed through the two individuals, in addition to what the jury awarded on behalf of the company for back pay and emotional distress. So there really wouldn't be a reason to send it back for that. But to go on with my argument with regard to individual liability, the second prong we have here is that on the verdict form, there was no special interrogatories that put the defendants individually on there. It's almost a feeling of common sense that attorneys and judges have, that each individual defendant should have a line on that verdict form. And here the district court put together the corporate defendant, the two individuals, and didn't give the jury an opportunity to go through the evidence and the elements.
Mr. Armentrout, setting aside the kind of your other arguments regarding the evidence, but with respect to the lack of a line for the individual defendants on the verdict form, does that error by itself require retrial for all of the defendants?
I think that's a similar question. And here, I say that no, I don't think so, because there's not been an allegation that the damages would have been any in addition to what was awarded for the plaintiff that the corporation's not already responsible for. But I have seen situations where the line on the verdict form does have a line that says, are there additional damages and emotional distress that are attributable to this individual defendant, particularly in sexual hostile environment claims. Here we're just talking about a decision to terminate, which is a discriminatory discharge case. So I don't think that it would need to go back just on that. I think that the judgments against the individuals could simply be vacated because of it. But I do believe that it's important that if this court were to say that an instruction is necessary and with regard to the standard, that it also say that an individual line should be given to the defendants, in particular because of this court's decision just recently in the Hawkins versus Grinnell case, in which the court held that a same decision instruction should be given to any defendant under an Iowa Civil Rights Act case if the motivating factor standard is going to be used. And that should also apply to an individual defendant facing liability under the same act. And here, the prejudice is pretty clear, in particular with to Mr. Kopic's case, who was the production manager who was called down because there was an altercation on the plant floor It's undisputed in the record, he didn't know anything about a back restriction being removed from Mr. Rumsey's doctor or the background of his restrictions or anything that was happening. He just walked in and witnessed and had to confront a very angry Mr. Rumsey and confused, and the record shows the testimony of Mr. Kopic. I believe if,
Counsel, I'd like for you to, I understand where you're going on your individual liability. Could you speak to your directed verdict issue and why it is that you believe that Mr. Rumsey did not satisfy the elements of being for his disability discrimination claims?
Absolutely, Your Honor. Under the Iowa Civil Rights Act for a disability claim, one of the prongs is that the plaintiff is qualified to be able to do the job with or without accommodation. And here we raise that point at summary judgment and said Mr. Rumsey, at the time of on the date of his termination, had a 10-pound lifting restriction. There's no plant positions in the entire plant that permit anyone in there that couldn't lift more than.
What about their argument that, the Civil Rights Act isn't limited by your particular job classifications, your client's job classifications? The fact is he was doing that beading job or whatever it's bead taping job, I guess it is. Why can't that be a reasonable accommodation? At least up to the jury to just.
Right, and it is the plaintiff's burden to come forward with the accommodation, or at least create a fact issue on that. And the problem we saw here was at the time of summary judgment, the plaintiff's position was he was on light duty, let him continue on light duty. I think the plaintiff saw the fatal flaw in this at the time they went to trial, which is why the bead taping position suddenly came into focus. They realized there has to be some accommodation, we can argue, allowed him to do the position. The problem with that is Mr. Rumsey only worked that bead taping position for a couple of weeks as a light duty position in the 2 weeks before his termination. He was never assigned to that on a permanent basis. That position wouldn't have allowed him to do the essential function of lifting. In fact, the only evidence in the record was Mr. Kopic, the production manager, that said we couldn't have made the bead taping position into a permanent position because so much bead would have been created by a person doing nothing but that 24 hours a day, we wouldn't even be able to use it all.
Saying that with that job, the evidence in the record shows that there wasn't enough work to make that a full-time job.
Right. Right, that was the only evidence in the record. So getting back to your question, Your Honor, we do believe directed verdict should have been granted at that point because of the lack of evidence on the qualification.
How does it?
Will it be fatal to the retaliation claim, would it?
That's a separate claim. That's right, Your Honor. We've also moved for directed verdict on the retaliation claim. The problem there being that the protected activity alleged by the plaintiff all occurred after the alleged misconduct occurred.
Doesn't he have to be qualified to do the essential functions of the job even to pursue a retaliation claim?
Yes. I mean,
Isn't that under the jury instructions as I read them?
That's right, Your Honor. Correct.
How does the timing of his termination before he had reached MMI, and so before maybe anyone could determine whether or not he'd be able to perform a job with or without accommodations, how does that play into the analysis of that second prong?
Yeah, I think that's the essential part of this case, Your Honor. Because Rumsey had never reached MMI on his shoulder injury, we never got to the point, the employer never got to the point where you sit down and say, all right, here's your permanent restrictions. Now what are we going to do? Is there a position for you? What can we do? What do you suggest? What your doctor suggests? We were in the phase before then when he's still healing, he's still in pain, and that shouldn't give the employee some sort of an insurance or get out of jail free card to start an altercation or a problem in the workplace. But the problem being, they never crossed the bridge of deciding whether they could at the time make bead taping a permanent position or find something else or create a position because he was still healing at the time, which I submit makes this more of an ideal workers' comp retaliation case than it does a pure disability type case.
And I understand kind of, that does create a problem with the way this case was pled and the way it was actually tried. I guess my concern is if we were to agree with you and say the plaintiffs didn't meet that second prong because he couldn't identify a job with or without an accommodation at that point. I understand your position is that there was an altercation, so there's another reason to terminate him. But my concern is that allowing employers then in this situation to terminate someone before they reach that point, and then say, sorry, there's not a discrimination claim here because because at the time of your termination, you hadn't reached MMI, and so you couldn't perform your job with or without an accommodation. I guess that's my concern with going forward, with accepting your position on the directed verdict issue.
And I see that my time is about up. May I respond to the justice?
Yes, please do.
I do think there are competing interests here, and they're very, very important ones. There is an interest that we want to give employees light-duty positions after a workplace injury. And what message would be sent if, a decision comes down that if you give light duty, you're also starting the path down or establishing a disability claim by that person, depending on what may or may not happen later. I think it's better to say that just giving light duty to someone to get them back into the workplace should not begin the creation of elements of a disability case. And so that's kind of, the problem that we have here when someone doesn't reach MMI at the time of the termination decision.
Thank you. Mr. Albrecht?
May it please the court, counsel. My name is David Albrecht, and along with Madison Fidler Carlson, we represent the plaintiff, Ron Rumsey. Your Honors, this appeal is really a tale of two different cases here. There was the case that was tried at the jury and the evidence submitted therein, and after which the jury found 3 times unanimously that the defendants, plural, engaged in discrimination. And then there's the case as reported by defendants' brief, in which they ignore that evidence, contradict their own witnesses' testimony. Yes.
You mentioned that the jury found defendants plural. The jury didn't have an option except for to find all defendants or no defendants. Is that correct?
Correct, Your Honor, which actually, if anyone was at peril there, it was the plaintiff. Because when it comes down to it, there were 2 defendants in this case. There was individual defendant Kopic and defendant Mullaney. Yes, there's wins or windows, but that's going to be decided based on agency principles, only through the actions of the individuals in this case. So when we're talking about the jury verdict and the questions posed to the jury, just ask this question. When we have 2 individuals, could the jury, if the jury believed only one of them and not the other one had engaged in illegal discrimination, could they linguistically have said defendants, plural, they engaged in misconduct? They could not have said it. If anyone was at peril with the way those were phrased, it was actually us. Because if the jury thought one of them didn't do it, then they would have had to have said no based on how they were actually constructed. So I can understand a case where maybe there's 12 different defendants or groups of defendants that engaged with each other differently, where you would need to separate everyone. But that was not this case. Defendants defended themselves as a block. Every time they were referred to by us, by defense counsel, by themselves, it was Kopic and Mullaney as the defendants. There was no daylight between them.
Well, you would agree, at least in terms of best practices, and maybe it didn't happen or wasn't necessary in this case, but the better practice would be to have a line for each of the defendants. You would agree with that, right?
I suppose, Your Honor, that you could certainly make the argument that it would have been easier to say individual defendant Kopic and individual defendant Mullaney. But in that sense, you would have said defendant, singular. And you couldn't have said defendants without finding both.
But the defendants actually asked for separate lines in this case, correct?
Yes, they did, Your Honor. Yes. And again, instructions are to be based on the facts of the case. And I can understand in a different case where that might be more necessary. But this whole idea of Mullaney and Kopic as separate individuals is pure fiction of the appeal and was not...
So let's get to the facts of the case. What evidence in the record is there that Mullaney and Kopic had decision-making authority to fire?
Thank you, Your Honor. All of it. So the first time we heard that Mullaney and Kopic lacked the authority was in defendant's appeal. So Mullaney testified on examination. We asked her, and you made the decision to fire Ron shortly after he left, correct? Answer, yes. course, we didn't say, and you had the authority to do that, right? Because defendants then asked them, and you, Ms. Mullaney, have fired other people for misconduct, haven't you? Yes. Mr. Kopic testified that we, meaning he and Mullaney, made the decision to fire Ron before we spoke to Pete Crevaro. It was their decision to make, and defense counsel also elicited testimony from defendant Kopic that he had fired other people who had engaged in misconduct.
Wasn't there evidence that they had to clear it with Crevaro, that they had to go to Crevaro and get his authorization before they went and did that?
No, Your Honor. The closest it came was defense counsel asking Mullaney, after she had testified that she had already decided to fire Ron, didn't you want to run this by Mr. Crevaro? And she said, sure, we were firing somebody, you know, it's a thing I'm going to run by my supervisor, but Crevaro testified, they already made the decision before I got to work.
Well, I understand the make the decision, I mean, but, you know, we're talking about not is there evidence that they had decision-making authority, but should the jury have been entitled to decide the issue? And, I mean, isn't it at least a disputed issue of fact whether these two individuals had sufficient decision-making authority on their own without Crevaro?
Well, I would say no, there's no dispute because both of them testified that they fired Ron. And the defendants and defense counsel told the jury that Kopic and Mullaney fired other employees for misconduct. And you don't get to fire other employees if you didn't fire the first one. And to the extent...
There's a distinction between firing somebody and then getting it approved by HR. Right?
And this was HR, Your Honor,
Right.
and nobody...
But-
oh, sorry, go ahead.
But, I mean, if they say we fire people, meaning they have the authority, but they're also going to consult with somebody up the food chain.
Sure, and the evidence in this case was that they made the decision to fire Ron, and then Liz Mullaney told Pete, hey, we made the decision to fire Ron. Are you good with that? Yeah, he agrees with their termination decision.
At the time that, when was the decision made by the court that there would not be 3 lines on the verdict form? So at the time that all this testimony was coming in, did it matter? Or was there only going to be 1 line at that point?
The decision was made after the evidence had came in, and it was clear that there really was no distinction between the defendants here. And I would say...
Could I ask you to shift, if it's okay, to
Sure.
the directed verdict issue? So do you agree for each of the claims, they're one of the elements, including the retaliation claims, each of the claims, one of the elements was that Mr. Rumsey could have performed the essential functions of the job with or without reasonable accommodation. Isn't that correct?
I believe that it was drafted in the verdict form, Your Honor. And one thing that keeps coming up about this qualified argument is a lot of trees have died for it, and it doesn't apply. Why? Because the defendants didn't fire Ron Rumsey because he couldn't lift heavy things. If the defendants had fired Ron and said, we got no work for you, all right? You can't lift anything, we've got nothing for you. Then we would be arguing over whether or not there was an accommodation for him. But that's not why they fired him.
Regardless of that, the instructions are the law of the case, and that's an element of each and every instruction. So in order to get to the jury, you had to show he could have performed the essential functions of the job with or without reasonable accommodations, right?
Yes, and we did.
Okay, and so what was the accommodation, the reasonable accommodation that we're talking about?
So this again becomes difficult because the interactive process appears when the employer and the employee are talking about restrictions and whether or not they can accommodate it. The conversation never happened because they were already accommodating Ron. This whole decision about MMI not coming until January is false because in July of 2015, Ron's back impairment, the real serious one that gave him the lifting restriction, was at MMI. 5 months before he was fired. The shoulder was still not at MMI till January, but that was never going to affect his back impairment or his lifting restriction.
So what job was he doing then between July and December?
He did a series of different light duty work. He did bead taping job. He also did essentially quality inspection of glass work. And the important thing here is defendants keep talking about this general job called Material Handler 2, a specific function of which was IG wrap. That's the job Ron was doing in January when he got hurt. Defendant's internal system reassigned him out of being a Material Handler 2 to being a fabricator, which is another general description a specific function of which is the bead taping job. Now,
Was that a permanent job, or was that just a light-duty job that was made available while he was on work comp rehab?
well, Your Honor, it was a permanent job, and here's why. Just because somebody says light duty doesn't mean it's temporary. And the testimony in this case by Liz Mullaney was that the bead taping job Ron was performing at the end of his tenure there was full-time. That's what she said. It's full-time.
Did she say it was full-time, or she said he did it full-time, but it was light-duty?
I said, and that's a full-time job, correct? Correct. And Ron Rumsey testified that it was a full-time position. He might have not been doing 40 hours a week because he was missing work because of his back ailment, for which he sought the accommodation to sit down, but both Ron and Liz Mullaney testified it was a full-time job. Clay Coppock can disagree, I suppose, but at worst, that just creates a disputed fact the jury already decided. So this idea that Ron was on light-duty work comp does not apply to the lifting restriction because his back, the injury for which he received the permanent restriction they talk about all the time, was permanent 5 months before they fired him. And you know what Liz Mullaney said about his lifting restriction? Quote, not a problem. That's what she says. It's not a problem. And I asked, okay, Pete Crevaro, in January, when Ron Rumsey's shoulder restriction becomes permanent, would you fire him? He says, no, of course not. What would you do? Well, we would sit down and we would see what we can do for him. So they are asking the court to fire Ron to make a decision that defendants didn't make and said they would not have made. All of their authority comes from cases in which the employer fired the employee because they were unable to perform the essential functions. And then the employee brought a claim saying, yes, I was. That is not why they fired Ron. So that conversation about what reasonable accommodations were available never came up. They're speaking in hypotheticals because as of July, his restriction, his 10-pound lifting restriction was permanent. Liz Mullaney admitted on the stand, I knew it wasn't getting any better, it wasn't going anywhere. Could you have continued accommodating him, we asked? Yes, she said.
But I guess that's where I have a little bit of problems with your position that it was a permanent job, but then you say that they're accommodating him by allowing him to do that job.
Well, Your Honor, there's nothing inconsistent about a reassignment being a permanent job. You can permanently reassign someone.
To a permanent job. You can
Correct.
reassign someone to a permanent
Which
job.
they didn't, Clay Coppock or someone else could say they think it was temporary. Liz Mullaney and Ron said that was his job and it was full-time. In the system, he was designated as a fabricator. So as of July 2015, any temporary light duty became permanent because if Ron's lifting restriction truly disqualified him from work, then they could have legally let him go in July. But they didn't do it. And we asked them why, and they said because it was not a problem.
Mr. Albrecht?
Yes.
The instructions are what they are in this case, but I tend to agree with your analysis of the reasonable accommodation and how it relates to these kinds of claims. Is it your sense that regardless of how we decide this case, perhaps we need to clarify how that particular piece works in a case where the grounds for termination are wholly unrelated to the ability to perform the job? I mean, here it's not disputed, I don't think, by the employer why they fired him. Right?
Correct. Literally every bit of evidence was them saying they didn't fire him and they would not have fired him because of his physical restrictions. That's pure attorney speak. So I think the simple way to deal with it is to say, you make the accommodation analysis if the defendant is saying they can't accommodate them. And in this case, there were 2 reasonable accommodation requests and as of December 15th. He needed to sit down for his back impairment, which had been permanent since July, and he wanted an interpreter. Okay, those were the accommodations, and the defendants at trial admitted they could have accommodated both. Instead, they chose to fire him. And defendants continue saying that Ron's interpreter request came only after the meeting. That was a big factor in this case, was whether or not Ron requested an interpreter during the meeting on December 15th. And initially, all the way through Liz Mullaney's cross-examination, they towed that line and said no. The first time we heard from Ron about requesting an interpreter was after the meeting in a text message, okay? And Ron had said, no, I asked in the meeting for an interpreter because I had no idea what was going on, what happened to my medical restrictions, and I didn't know what I could even do at my job.
If I could shift to the $450,000 emotional distress award, is it true there were no, he wasn't treated by a mental health professional Is that correct?
Yes, Your Honor.
And did he have any physical symptoms?
I think he may have testified to some general symptoms. I mean, he shunned his family. I don't recall any like physical, like vomiting or anything like that. But what we have to remember here is that emotional distress damages are to be assessed on how the conduct affected the specific individual, not generally. So while defendant's misconduct may have affected someone else differently, that's irrelevant. The relevance is how it affected Ron Rumsey. And Ron Rumsey is somebody that had been treated differently his entire life. And he grew tough skin as because of it. If he went and saw a mental health professional every time somebody discriminated against him, he'd probably have room and board taken care of. But he didn't. He figured out a way to deal with it himself. And so it said something then, and it says something now, that a middle-aged man who had been treated differently throughout his life had to stop his...
That's a wonderful argument about his character, but doesn't that mean that his damages are less? I mean, am I missing something?
Yes, Your Honor.
It makes he's a very admirable person. You've convinced me of that. But are his damages $450,000?
Yes, Your Honor, and where I was going next is the fact that someone can be as tough as Ron and still have to stop testifying because he's crying, because he's talking about what it meant to him to lose that career, that tells you how deep they hurt him. The district court who observed the evidence said it was clear to the district court that defendant's misconduct and discrimination had severely damaged his mental well-being. So to mess with that emotional distress verdict, the standard would be to take what the district court said was clear and find that it is clearly untenable and clearly refuted by the evidence. And that is not this case. Perhaps somebody may have come to a different decision. Perhaps they would have given him more. But in the Smith case, as we cite, that is not a reason for this court to disturb or touch that verdict. I see my time has expired, Your Honors, if I may conclude.
You may wrap up.
This whole verdict is about responsibility, and for years, defendants refused responsibility. Ron was fired in 2015, and they refused it until a jury of their peers held them accountable 3 times unanimously. They still refused that accountability. They refused to listen to Ron, and they fired him. They destroyed his livelihood and his career and his self-identity. We ask this court to listen to that jury, affirm it in all regards, and remand on the sole issue that unfortunately we didn't get to, which is the entry of another $169,000 in front pay. Thank you.
Thank you. Mr. Armentrout.
Thank you, Your Honor. I'd like to first address the questions with regard to the emotional distress award. This court has had a couple opportunities in the last few years, Haskenhoff and Hawkins, to take a look at whether the Jasper versus Nysum case is still good law. And we submit that it is. It's a reasonable way to look at emotional distress awards and evaluate them. And we do believe that in the absence of more severe symptoms that manifest themselves physically or medical diagnosis or treatment, that the award should be, on the lower side, and this award was excessive. The testimony was that it was the common consequences of, as illustrated in Jasper, that Mr. Rumsey had, financial stress and so forth. But what I'd like to use that as a segue into one argument we didn't get into in the beginning of my argument, which is the $100,000 workers' comp settlement that was paid to him in February of 2017. We've made a number of arguments about why that should have been admitted by the court as to back pay, or should have been at least offset by the district court. But we also believe that an important thing on the emotional distress is that should have come in so that the jury could understand about the award being paid with regard to past emotional distress. Mr. Rumsey and his wife testified that they had financial stress because he was terminated in December with regard to buying Christmas presents and so forth. And although a common consequence of a termination decision, it did allow for the emotional distress instruction to go. And we believe, had we been allowed to say that he wrapped up his workers' comp case later with a $100,000 lump sum payment, that would have been something that would have ameliorated the damages in this case. We've cited a few cases that show when the plaintiff receives funds, it doesn't matter if it's family helping or from a settlement of another case or other funds that come in, if it tends to lessen emotional distress, which it normally does, particularly a $100,000 payment like that, it's something the jury should have been allowed to consider. With regard to whether the bead taping position was a permanent position,
I don't care whether it was a permanent position. If it was a job that really could have been done full-time, that's, to me, the real kind of the nub of the matter, because he was doing it. If it was a job that could have been done full-time, then it seems to me the jury's entitled to conclude that that might have been a reasonable accommodation, right?
that's right. And actually, Ms. Mullaney did not say that he was assigned to that position on a permanent basis. She made it clear in her testimony that that position was given to him as a light-duty position at the time. It was certainly a temporary position. The records also show that he barely put any hours in at the bead taping station. We put in Ms. Mullaney's calendar into the record, showing that he actually only worked 6 hours the week before his termination at the bead taping station. But as we discussed earlier, if the court would direct its attention to Mr. Kopic's testimony, which is in the record, when asked whether that could have been made into a permanent position, he testified, no, there's no way we could have, because of it's a small part of a bigger position, and we can't have someone continually pumping out bead. We'd have way too much supply there. That's the only evidence in the record that it actually could not have been made into a permanent accommodation in this case. I also want to point out one thing. Mr. Albrecht said that there was several questions in which Ms. Mullaney or Mr. Kopic admitted that they had the authority. I think there's some liberties probably taken with the record there. There was a question about previous terminations that had happened while Ms. Mullaney was there that she was aware of, and she did not testify that she fired anybody. The testimony that's in the record, and this is, the court can check it out, it's the appendix at page 322. That's what he's referring to. She actually said, we terminated, meaning the company took a look at the situation, again, run by supervisors and their directors. There was never an admission that she ever did anything as a HR manager. I see that my time is just about up. With regard to relief, we would ask that the court reverse the jury verdict because we believe directed verdict should have been granted in this case. And if not, then because of the evidentiary errors, we're entitled to a new trial. If the court is inclined to affirm the verdict in some manner, we ask that it be reduced, the emotional distress portion. And if that's the case, we also ask that the individual judgments be vacated. Thank you.
Thank you. The case of Rumsey versus Woodgrain Millwork et al. Is hereby submitted. And the third and final case for the afternoon is Daniels versus Holtz, and that will be submitted without oral argument. Court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.